my name is Natalia Willette, and I am a real estate and estate planning attorney here in the state of Florida. And today I wanted to talk to you about a special circumstance in foreclosure sales, and that is bankruptcy. So bankruptcy can affect your foreclosure sales depending on when the borrower or somebody else that's a named defendant in the bankruptcy filing files for bankruptcy relief. So in a foreclosure case, there are people that are dealing with an indebtedness, right? And so bankruptcy is a form of federal relief in which they can try to either discharge the personal obligation for that debt or come up with a payment plan through a Chapter 13 proceedings that allows them to pay back what they owe over 3 years or 5 years, depending on their income. When you are a bidder at a foreclosure auction, a couple of things can happen if somebody files for bankruptcy. And people do tend to file for bankruptcy at the very last minute because that's when they actually take it seriously that no, really, your home or investment property is going to be sold at a foreclosure auction because of your delinquency. So they often file maybe the day before or the day of the sale, which makes it very difficult for an investor to know that there is a bankruptcy in place prior to the bidding process. So if there's bankruptcy filing and the bankruptcy has been filed after your certificate of sale has been issued, generally, and I say generally because it's not under every circumstance, but generally your title should be valid. This does not mean that there won't be an objection to sale filed by the debtor saying, oh, I filed for bankruptcy relief, etc., etc. And you definitely will need an attorney to deal with that and get the objection dismissed and get your certificate of title confirmed. Because once they file an objection, that must be set for hearing. It's required to be set for hearing by law, so that a certificate of title can be issued and their objection can be heard. If you have a bankruptcy filing that's done before the certificate of sale is issued, I'm not talking about the certificate of title, I'm talking about the certificate of sale. That's just the receipt that you get for being the winning bidder at an auction. If they file for bankruptcy relief before that, and timing really does matter, then you are dealing with having just purchased a property at a void sale. And you have a couple of options. You can either accept that it's a void sale and then need an attorney to get all of your money back for the void sale, or you can hire an attorney to represent you in federal court, and they have to be admitted in federal court to get relief from the bankruptcy judge, permission to hold that a sale stay due to the bankruptcy filing is no longer in place and it's retroactively annulled, so that it retroactively validates the foreclosure sale. But there have to be bases and reasons for that. It doesn't just happen on every occasion. So it's absolutely essential, if there's a bankruptcy filed in the case in which you were a bidder, a winning bidder, you must talk to an attorney as soon as possible. My name is Natalia Willette. For our channel, for more videos like this, we can get in-depth information or just general information about what can happen in your foreclosure sale process, in your eviction proceedings, or in your tax deed investments or estate planning needs. Subscribe to our channel. My name is Natalia Willette. Good luck out there, investors.